Chapter 9, we deal with the second two requirements of contract law, which cover capacity and legality. So contractual capacity is when the person has a mental status that they understand what they're getting themselves into by signing this contract. So minors, people under the age of 18, are allowed to legally enter into contracts. However, it is voidable by the minor. So if a person under the age of 18 enters into a contract with a person over the age of 18, the person that's an adult cannot void the contract, but the minor can. Then we'll also talk about people who are mentally incompetent at the time that they sign the contract. Those could be voidable as well. And then obviously we have to have legal purpose. So the minor's right to void that contract is called their right to disaffirm. So that is what they would have to do upon reaching the age of maturity. So say for some reason the minor goes out and gets an apartment before the age of 18. Maybe they started high school early and they graduated and they're 17. They could go get that apartment, and if the landlord would allow them to sign that lease, they could move in and start paying the rent. Well, then say when they turn 18, they decide, oh, I don't like this apartment anymore. Well, they could void that contract. As long as they contacted the landlord and said, I want to disaffirm this contract, I'm now an adult, they would no longer be liable. They would have to pay for what they used. So this ability to disaffirm doesn't get the minors off without paying. It just does not, for future liability standpoints, things that they have to pay in the future, they can get out of those. And they could do it verbally, call the landlord and say, hey, I no longer want to be a part of it, or by actions and actually just move out and not make that next payment. All property has to be returned to the other party. That is called restitution when you return the property. They have to pay for those necessities. So that's what this liability for necessaries is saying, that if they have a contract for food or shelter or clothing or medical attention, they will be liable for what they use. They just are disaffirming that future liability. Now, on the other hand, if they don't want to disaffirm it, if they don't want to void it, they want to continue on with this contract, then they call that ratification. So once that minor turns the age of 18, they can make their next payment on that lease, and they've now ratified that contract, and they are liable for the future rental payments because now they are of legal age and they made that decision to continue on with that lease or whatever contract they're involved in. Then we get into people who don't have the mental capacity to understand the consequences of their actions. So that could be intoxicated people. So if you are so drunk, and I think that's why Las Vegas has made some changes to their marriage laws, because they would have people who enter into a marriage contract. I mean, marriage basically is a legal contract, intoxicated, and then they wake up the next morning and say, oh my God, what did I do? I did not comprehend the consequences of my actions. So now I think there's like a 24-hour waiting period and things like that before the marriage can happen. But maybe say you go out and you buy a car and you are intoxicated and you sign the agreement and everything. Then the next day you go in and say, hey, I didn't know what I was getting myself into. So again, you'd have to do it in a reasonable time upon sobering up. The contract would be voidable by that person who does not understand the consequences of their action. So then when we get into this mentally incompetent persons, there's different levels. If the person has a court-appointed guardian, so it's gone to courts, the courts have said, hey, this person is not mentally stable, they cannot make these types of decisions on their own, and there's a specific guardian, a parent, a brother, a sister, whoever has been appointed to look over that person, then that mentally incompetent person cannot even enter into a contract. It would be a void contract because they do not have legal capacity. If they're not that, so maybe they've just suffered from some mental illness, maybe they're on disability, but I mean, it's not to the point where they have a guardian. they could enter into a valid contract. It could be voidable if at the time that they entered into the contract, they did not understand the consequences, the nature, the purpose, the scope of that contract. And then as soon as they maybe go home and talk to somebody else, they realize, oh, I can't do that. That becomes voidable. If they do understand the consequences of those actions when they sign that contract, then it is a valid contract. Okay, then our last requirement for a valid contract is legality. So it has to be something that is legal in the federal and state law. If it is illegal, then it's a void contract. So some common examples, I gave the example of like selling marijuana. That's something that's going to be legal probably in more states, but right now it's still not legal in the state of Ohio. If you entered into a contract to purchase marijuana, that is not a legally valid contract. You couldn't take that to court. But some common ones that are listed here on this slide are usury, which is an illegal rate of interest. So a lot of times those like payday loan places, some of those have shut down because they were charging illegal rates of interest. So I think in the state of Ohio, the interest rate cannot be more than 24%. Well, if you really did the math of the amount of time that you borrowed the money and the amount of interest that they charged you, they were charging you well more than 24%, and that was illegal. So some of them did shut down because I think they couldn't afford to do it in the legal ways. Gambling is another thing, and we've had some of those gambling places that we have had in our areas. Those have shut down, and I think it's because there was some gambling that was legal and some that was not legal. So they had machines or tables or whatever that were not legal in the state, and they got caught and they got shut down. Contracts that are contrary to public policy. So there's two that are common in business. There's the covenant not to compete in the sale of a business and a covenant not to compete in employment. So if you are, so say like I'm a CPA. So say I had my own CPA business and I want to retire. I could sell that business to another CPA who wants to, just kind of step into a business that's already has customers and already operates. But because it's kind of a personalized service, my customers probably picked me. If I would in turn say, oh, well, I've changed my mind now, I don't want to retire, and I open another CPA business 20 miles away in 6 months, chances are all of those customers are going to follow me. So then the person basically bought nothing. So then what you would do is you'd have that person sign a covenant not to compete. So you cannot open another accounting business in a 50-mile radius in 5 years. So it has to be reasonable. So again, if I said in a 300-mile radius for 10 years, that's not reasonable. What the courts would do is they would just reform the contract. They wouldn't say, well, the contract is void. They'd say the contract is still legitimate, but we're just going to reform it to say maybe that reduce the mileage and reduce the time frame. So then it doesn't stop me from ever opening an accounting business. I just can't do it close to this business that I sold. If you were like a sales rep, many times if you leave, or when you get hired for the company, they will make you sign this covenant not to compete. So it will say that you may not go to work for a competitor or start a similar business for a reasonable period of time, and again, in a reasonable geographic area, because they don't want you to come in, get all their trade secrets, get all their information, get access to all their customer lists, and then go start your own business and then start to compete with them. So those are both things that could be signed in a business. There's also unconscionable contracts and exculpatory clauses. So an unconscionable contract is one that is so oppressive to one party. So it's so unfair that one party is going to suffer. Then they may step in and say, no, that person does not have to fulfill their end of the deal. It's an unconscionable contract. There can be exculpatory clauses where it releases one party from liability. So, some of them may be kind of legit. So like I give the example of amusement parks or skydiving, racetracks, things where you are assuming the risk if you're going to participate in that. So you know that there's a chance if you go on one of these crazy tall roller coasters or those demon drops that drop you down, you could possibly have a heart attack. So you are taking that risk going on that. Or if you're pregnant, you could harm your baby. So there's signs about those things as you're lining up to take those rides. So you're assuming the risk. If it was something that was, totally negligent of the amusement park's fault, or negligence on the skydiving, something not quite normal, you could still sue them if they are negligent. But if it's really just you had a heart attack on that ride, you probably are not going to be able to sue the amusement park because you did assume the risk. Then we get into assent. So assent goes back to, do I have genuine agreement? Was there really genuine agreement? So then there's a couple different types of mistake situations. It could be mistake of a future value, and that contract is going to be enforceable. So say maybe you take a tip from your stockbroker that says, hey, buy Amazon stock because I think they're going to go up double in the next year. Well, then you buy that stock, and darn it, Amazon doesn't go up double. Maybe it goes down. Well, you can't go back and sue and say, hey, I thought it was going to double. That's a risk that you took. No one knows the future value. Everybody's just estimating. If it's a mistake of a material fact, then that is one that does release the parties. If it was just one-sided, which is a unilateral mistake, then that person has the right to cancel the contract. So say you're buying something online and you're looking at the pictures and you feel it is made of something, it's a metal product, and then it really comes to you and it's plastic. And nowhere in it did you give you the specifications. You could back out of that, return it and say, I didn't understand. I thought it was metal. It's not. If it's bilateral, where both parties are confused, then either party can get out. If it's just unilateral, only the one person that's confused could void the contract. Then there's fraudulent misrepresentation. So we talked about fraud when we talked about our torts, but a fraud is a misrepresentation of a material fact with the intent to deceive. An innocent party relied on this misrepresentation and suffered some sort of injury. So if it's a fraudulent contract, then the innocent party can rescind it, cancel that contract. They would seek to be restored or restitution, have whatever they paid returned to them, and they could actually sue under tort law and seek damages for any lost revenues or time or whatever. Then undue influence and duress. I talked about these, I've hinted at these in the past, that there's not true agreement if there's undue influence or duress, but you do want to understand those. So the innocent person, the person who genuinely did not agree to it because they were under undue influence, so maybe it's a parent who influences you, a husband, an attorney, there's some sort of a special relationship with this person, and they're putting pressure on you to enter into this contract. Then you agree because you feel forced. Well, that is undue influence, and it could be voided by you. Or duress. Duress is a threat of physical harm or a extortion in some way. So they say, I'm going to come back and hurt your family if you don't sell me this car for cheap. That would be, you're going to do it because you're scared, but you could void that contract because you were under duress at the time. Then the last thing that we touched on in the last chapter was to say that certain contracts have to be in writing to be enforceable. It's covered under the statute of frauds. So the list of it is any properties or any contracts that deal with real property. So mortgages that you're going to enter into, home sales or purchases, those have to be in writing to be enforceable. If the contract cannot be completed within a year, it's considered a long-term contract. Those long-term contracts also have to be in writing to be enforceable. Collateral, so like you're going to co-sign on a loan. So say your child goes and gets a vehicle loan and you're a co-signer, that can't just be verbal. You have to put it in writing to say, I will be liable on this loan, or I will be liable on this lease agreement. That has to be in writing. Prenuptial agreements, because again, it's going to be a he said, she said kind of a disagreement if it goes bad. Those prenuptial agreements have to be in writing to be enforceable. And any contracts of sale of goods that are over $500 have to be in writing to be enforceable. So a lot of times that's just going to be a receipt that you sign, but that still is in writing. Okay, so that kind of completes the requirements of contract law. The next chapter, we will get into some more details of what happens if the contract doesn't pan out the way that we hope it would.